So you think it will take 4 hours? 3, 4 hours? I was thinking, what can we discuss for 4 hours?
That's respected.
All rise.
Good morning.
Good morning.
Good morning, all. We're here for a case management conference in the matter CFI 5, 2018. The claimant is represented by Adari Legal Consultancy. Lead counsel is Ghassan Adari. The defendants are represented by Taylor Wessing Middle East LLP. Lead counsel is Paul Blakely. Assisting is Mark Fraser.
Please, Mr. Judge.
Yes. Yeah. Good morning, Your Honor. Yeah, this is in the case Drees Sommer versus Toscana. In this case, Drees Sommer, the claimant, entered into a project management agreement on 15th February 2016. The parties agreed that the claimant should be honored for project management services, a monthly payment of 125,000. In the statement of claim, we also stated that the claimant provided the service under the project management agreement and that the claimant sent monthly invoices in accordance with the project management agreement of 125,000 dirhams per month. Then on June 12, 2017, the defendant terminated the project management agreement by sending an email to the claimant, and thereafter the defendant did not pay. Further, we stated in the particular of claims that the project management agreement is governed by UAE law. The defendant then raised the issue that the case is not answerable. Paragraph 17.1 of the court rules provides that a concise statement of facts on which the claimant relies has to be submitted, and in our opinion this has been done. We said there was a project management agreement, we provided the services under the project management agreement, we sent invoices, the agreement has been terminated, so it is very clear what the facts of the case are. As the defense of the defendant just show that, as in our opinion, this case is very difficult to defend.
Any comments from the defendant?
Thank you, and thank you to my friend. The issue that the defendant has with the method in which this case has been pleaded is actually very straightforward, in that it doesn't currently understand the way in which the case is pleaded. As my friend has said, it appears that the claimant is relying solely on two facts, namely that there is an agreement containing a payment provision, and that, second of all, invoices have been raised thereunder. Our view, as that view of the defendant, is that this is much more complex than that, in that if we were to go to the contract, appreciate the purpose of this morning is not to delve too much into the factual basis, but if we were to go to the contract, it says that the payment is in consideration of the provision of services within a specified period of time. The claimant has not sought to address these issues. It has actually overlooked them in its particulars of claim, which is where the objection under RDC 17.17.1 arises, and has simply asked the court to enter a judgment on an incomplete representation of the contract. Unfortunately, the situation then deteriorates from there. This position was raised in the statement of defence, saying that there was no answerable case. The claimant then proceeded in its reply to the statement of defence in a manner that was entirely inconsistent with its particulars of claim, and commenced making a number of unsupported allegations against everybody involved in the project except the claimant. It was JUSI, it was SWA Architects, it was EMA, it was the local authorities, it was the defendant. Again, unfortunately, if you were to look through the paperwork to try and find evidence to support any of these positions, you simply wouldn't find it. There's also the unfortunate submission that the contract was terminated because of the existence of the Qatar sanctions last year. Again, if you were to try and find evidence of that, you would see that that is pure speculation. The defendant's position is that the purpose of the particulars of the claim is not to cast as many allegations as possible, hoping that one will stick. The purpose of the pleadings is to set an agenda for the trial. It is to establish the framework in which the claimant will go about discharging the burden of proof that is incumbent upon it. And at this point in time, those elements are lacking. For instance, if we were to look at the draft case management order, which has not been agreed between the parties, we see that the claimant has suggested that it may look to instruct a delay expert. But with all due respect, this isn't pleaded as a delay case. There's no Windows analysis, there's no baseline program, there's no time impact analysis. It is not a delay case, and therefore we, as the defendant, simply don't know how we're supposed to go about instructing a delay expert, because we don't know the grounds on which the claim is pursued. On this basis, if we accept that RDC 26.35 states that the purpose, or one of the purposes of the case management conference, is to ascertain whether or not the case is sufficiently pleaded, the defendant's submission is that simply at this stage it is not. Therefore, we are inviting the court today to either exercise its case management powers and strike out the case under Rule 4.16, or submit an order that the case be properly pleaded in order to facilitate a more considered defence on the part of the defendant.
Your Honor, you can see from the statement of defense that the defendant knows exactly what are the issues of the case. And what the colleague was addressing is, at the end of the day, a question of burden of proof. Because the claimant has had an agreement with the defendant. This was pleaded in the particulars of claim. Under this agreement, he had to provide services. He said he provided the services without any exceptions. He said he had an agreement to get a monthly fee of $125,000, which was also pleaded. We sent invoices, and the claimant didn't pay. So now arguing that the case is not answerable is flawed, because they know exactly what happened. I mean, the defendant has in possession documents over 12,000 pages. Now to say that we don't know what this case is about or what we are pleading is flawed. The defendant, and this you can also see from the statement of defense, he knows exactly what this case is about. He's writing about 5 pages or even 6 pages. What are the agreements? What are the obligations of the claimant? And even in 1.4.3 on page 5 of the statement of defense, he said we haven't provided, or the claimant haven't provided the services. So basically, the question is, who carries the burden of proof? Can now the defendant say the claim is not valid because we haven't mentioned in the statement of claim all the services we provided? And according to paragraph 17.1, it has to be concise. And based on our particulars of claim, the defendant knows exactly what we are talking about, what is the case, what are the grounds of the case. And even, as you can see in our reply to the defense, there was also, after the termination, there was correspondence between the parties. The defendant sent the claimant an email, we will pay shortly. So now to argue that the defendant doesn't understand the case is from our side not understandable. They know exactly it's the case management provided as mentioned in the particulars of claim. So it's very clear what we are talking about, and it's on the defendant has now to prove that we haven't provided the services. Even in Article 2 of the Project Management Agreement, it provides that if client disputes any portion of request of payment, Article 2 of the Project Management Agreement is Exhibit SD1. It says, if client disputes any portion of a request of payment, client shall promptly notify Drees Sommer of the amount in dispute and the reason thereof. They never ever did, and now after we submitted the claim, they are arguing that they don't understand this case.
So there is a contract. There is a contract.
Yeah.
And I believe the parties did not agree on a CMC order, yeah?
We did not, no.
Okay. If the defendant wishes to strike out the claim, we should file an application to strike out with supported by evidence. Yeah? And this can be heard at a hearing to decide whether this case should be struck out or not. Today we have a case management conference in which we will move on to schedule the dates pursuant to the CMC order. Yeah?
Your Honor, I just want to address one point before we go to the particulars. I mentioned in the case management information sheet the approximately how many pages documents I will provide. I mean, this really depends on the defense of the defendant. I mean, we are in possession of approximately 12,000 pages. However, I assume it might not be necessary to submit this 12,000 pages to the court. Okay.
Your Honour, unfortunately, if there is a case management information sheet supplied by the claimant, that has not been provided to the defendant.
I don't see an information sheet before me also. I don't have a copy of the information sheet.
It's in the system. It's uploaded.
But it should be attached to the bundle.
Okay, then I apologize for this. Okay.
When was it uploaded?
May I address you? I think that the real concern of the defendant here is that the way the case is currently concluded, there isn't an agenda for trial, and we're at risk of going down a dangerous, risky route in producing any timetable. And I think the issue is best demonstrated by the reference in the draft order to expert witness reports. I think you would have to be considering whether expert evidence is appropriate, and there was no information before you on which to exercise that judgment. course, a strikeout application, as you have indicated, could be provided and submitted. There is another way of dealing with this, which would be in order for the case to be repleted so that it is absolutely clear what the case is about and what the issues would flow and whether expert evidence would be relevant. And that's, I think, the kernel of the defendant's concerns. And I may make the point to try and assist how we might move forward at this stage.
Your Honor, may I address you? I mean, I don't see the necessity to replete this case. In my opinion, in the particulars of claim, provide a concise statement of the facts. So we provided this, and even if you consider the reply to the statement of defense, I think it is very clear what we are pleading, and we do not understand the respondent, why he is repeating that he doesn't understand the case. If we say we need expertise, this is just in the case because if I read the statement of defense, this is basically not a proper statement of defense in compliance with the court rules. They are just raising questions whether we did this. They raise a question, or they just point out there could have been a delayed responsible and the claimant should be responsible. I mean, if this will be at a later stage a defense, then of course there might be a necessity to appoint an expert. But based on the very vague statement of defense, we don't know exactly what they will challenge, because in our case, in our opinion, we provided the court with the facts which are required for our claim.
Your Honour, if we were to go to the particulars of claim and the statement of reply to the defence, you will see again that these are positions that are genuinely believed by the claimant, but ultimately boil down to the court having to trust the claimant that the services were provided. And this is where the defendant relies on the terms of the contract, which says that the fee is in consideration of services. It is for the claimant to demonstrate that they proved that they provided those services, not for the defendant to disprove it. We can answer that question, we can defend that claim, but ultimately if they have a positive case that they are entitled to the monies under the contract, they are the ones that have to advance it, not the defendant. And if we then turn to the position that my friend has pointed out regarding the alleged particularity of the defence, we do admit that a skeleton defence has been provided. But in terms of the allegations made in the statement of reply to the defence, we see there is one allegation that SWA provided an insufficient design, and that led to the authorities being, or the authorities rejecting that design. Now, the question that the defendant has is, again, what basis do we then go and get evidence? Is it the case that we need to go to every individual at SWA who was involved with the project, everyone at the authority who was involved with the project, and get them to provide hundreds of pages of testimony in terms of every email, call, meeting, discussion, drawing revision? Or is it better that the claimant goes away and particularises exactly what the issues were with SWA's design, how that led to the effect on their services, and how it meant that they were delayed, but ultimately it is not for reasons that they were in control of. And this is where my colleague makes the point. It's really more a question of how this process is managed, because if we were to go and get evidence on the wide basis that I suggested, then the cost of administering this claim can rapidly exceed the values in dispute. We are only talking about a claim that's less than a million dirhams here. The same question then arises on exactly the same basis for the expert evidence. Do we employ an expert to simply review the entirety of the matter, 12,000 pages of documents, all because the pleadings do not contain particulars as to the actual allegations being made, but rather sweeping statements of, we have a contract, we issued invoices, if anything happened, it's not our fault. Our submission is that is simply not sufficient to set the agenda for trial, which we need to then instruct experts and to engage with this evidence, but also to assess what documents are actually relevant for disclosure in order to save the court's time.
So, Your Honor, may I just
just a minute. I went through the particulars of claims. The claimant's claim is that they have a contract with the defendant and they provided services and they were not paid for those services. This is a straightforward matter. Now, whether there were services or not, this has to be proved by the claimant. Yeah?
By the claimant, yes.
So the court will not decide only on allegations or submission as a particular of claim without supporting documents to those contracts, the work that had been done, what happened, the whole story with evidence. The court will not decide on just 2 pages of paper and the contract, that's it. There is work that will be done. So it's the claimant's case. The claimant should prove his case, and the defendant, if he's opposing the claimant's case, he has also the chance to defend, providing evidence also. So I don't see why the matter is now so complicated. It's just straightforward.
Thank you, Your Honour. The position of the defendant is that the claim can be better particularised to enable us to have more fruitful discussions about the time it will take to run that defence. The principle that a defence must be run is not disputed, but based on the information at present, the manner in which we go about that is unclear, because again we do not know how to restrict the volume of evidence we put before the court, because the parameters of the claim are so wide given the lack of particularity of the allegations being made.
But Your Honor, even if the claimant now has to prove all the services he has provided.
Not now at the CMC, I mean.
Yeah.
I mean, for the case.
Yeah.
But at least he should give sense of the defendant of what's going on, what is he claiming, what is he relying on.
But even to
so that the defendant knows how to respond to it.
Yeah. But even, I mean, the defendant clearly understands what this case is about. And to make this case more economical, it would be helpful if the defendant would have pleaded in his statement of defense what exactly we didn't do. Otherwise, we have to provide the court with the 12,000 pages. And I think, considering that this project went for several months, almost 1.5 years, the defendant should be in a position to state which services have not been provided in accordance with the contract. Otherwise, the claimant has a necessity to provide the court with the 12,000 pages, which would make the case extremely uneconomical. So it could be also an option that the defendant provides the court with a particularized statement of defense, so that the claimant exactly knows which particular services he is challenging.
Your Honour, while this is accepted that a particularised defence could be put before the court, the submission, as I understand it, is that the defendant is to make the claimant's case and almost prove a negative. The claimant is the asserting party. The claimant is the one that is saying that it is entitled to these sums. It is the claimant that has to prove. It is the defendant that has to defend. In turn, we will be more than prepared to take instructions from our client and submit a particularised offence in defence of a particularised claim which narrows the field in terms of exactly what allegations are being put before Judicial and the effects that it had on the programme, exactly what allegations are being put against SWA and the effect that it had on the claimant's ability to provide the services. Because the fundamental point is that the defendant does accept there is a contract, it does accept there is a management fee in place, but that is in consideration of services which the claimant has to prove that it provided, and then either has to prove that it provided or was unable to provide for reasons outside of its control. That is not found in the pleadings as currently stated, which means that on an evidential basis we will have to review the entirety of the project when it is perfectly capable of having the issues narrowed simply by a particularised statement of claim being put before the court.
Did you provide evidence with this statement of claim, particulars of claim? Or just
So far, I didn't provide evidence. So far, I did not provide evidence.
then I'll direct the claimant to amend the particulars of claim, provide their evidence, and the defendant to respond, and then we will have another case management conference hearing. Yeah? Fair enough?
Thank you.
Thank you.
Thank you.
All rise.
So in terms of the time,
Yes.
Yeah? We're both from the registry. Yeah, you were being observed by my colleague Delvin from the Academy of Law.
Okay.
I think she's already left.
Okay. So, get the packet.